Okay, I just want to welcome all of the attendees and Carrie Payne. Carrie Payne is the Assistant Deputy Director of HCD. She's going to talk about the MRLPP, which is the Mobile Home Residency Law Protection Program, as enacted by the legislature and supported by GSMOL. We will not have time to address anyone's specific complaints. If time is available, we'll try to answer general concerns at the end. Presentation is being recorded and will be posted on the GSMOL YouTube page. PowerPoint slides will be available. Also, during the presentation, we will post information about the MRLPP from HCD and from GSMOL. Okay, so now Carrie's already introduced herself, but I'll go ahead and introduce her again. So this is Carrie Payne from HCD. Okay, Carrie, go.
Perfect. Well, again, thank you very much for having me this morning. I'm really excited to be able to talk about the Mobile Home Residency Law Protection Program. It's one of several programs under my kind of purview, and it's really exciting to see interest and engagement in this. So I appreciate your time all this morning. And let me just start sharing my screen. Okay, great. Okay, Linda gave a great introduction about kind of what we're going to talk about this morning. Here's the agenda that I have laid out for us. I want to talk a little bit about the Mobile Home Residency Law Protection Program, how it differs from the Mobile Home Assistance Center, provide a brief overview about what the program is, how it was established by the legislature, the types of complaints that we intake through that program, really go over go over the application and really talk about the best way to submit a complaint, the complaint process. And if we have time, I have the kind of a general status, which I think we will. So our MRLPP overview. I wanted to start by talking about what the MRLPP does and how it differs from the Mobile Home Assistance Center. And I think this is really critical to set the stage for the Mobile Home Assistance Center, or for the presentation itself. HCD offers two types of complaint intake processes: the Mobile Home Assistance Center, which is a long-standing program, and it's permanent in nature, and the Mobile Home Residency Law Protection Program, which we're here to talk about today. It's a 5-year pilot program at this time, and it really only focuses on mobile home residency law. So the Mobile Home Assistance Center is kind of our overall intake. We can refer alleged violations for law or regs within the Department of Housing and Community Development jurisdiction. Most of those are health and safety complaints within parks, but we can also talk about, or we can also take action on employee housing facility complaints, occupational licensing. So HCD licenses dealers, salespersons, and manufacturers. And if there's any type of issue during the sales process or with their business, we can take complaints through our Mobile Home Assistance Center for that, regarding the sale, financing, titling of those homes. We also offer complaints for the manufactured home program itself. HCD is a state administrative agency for HUD, and we can intake complaints and investigate them related to the installation, inspection, or installation of those homes and any type of defects. Our most common complaints through the Mobile Home Assistance Center are related to health and safety complaints within parks. So things like risks to health, health and safety regarding electrical or sewage issues, or anything health and safety within the park. So the Mobile Home Residency Law Protection Program is strictly related to mobile home residency law. Mobile home residency law is the landlord-tenant law, and it really outlines the relationship between mobile home park residents and the park owners themselves. It's in civil code. And so all of that any violations or infractions would be handled through the civil court system. So HCD has no enforcement over MRL, and that creates a real gap because it is incumbent on homeowners to seek their own legal counsel and handle any issues on their own through the civil court system, which is why the program was established. It allows us to intake complaints related to MRL, go through a process, and refer those out to different contracted legal service providers to help homeowners enforce infractions of mobile home residency law. Oops, sorry about that. That went way too far. Apologies. Okay, so mobile home residency law, as Linda mentioned, was initiated by statute. AB 3066 in 2018 created the Mobile Home Residency Law Protection Act that allowed HCD to stand up the Mobile Home Residency Law Protection Program. The legislative intent of that program was to afford manufactured homeowners an additional avenue to protect residents against violations of the MRL. And that additional avenue is really critical for everybody because there are some limitations to the program, which I will go over. This is not the only way or the only program for homeowners or residents to enforce the MRL. They can people can secure their own legal counsel or go through the civil court process on their own, but this is an additional avenue for assistance and support. A report to the legislature with the program recommendations is included in HCD's 2021-22 annual report. I just checked this morning. It is not currently posted to our website. I do have the report section for MRL that I'm happy to share or email out as requested. Currently, the program is set to sunset January 1, 2024. Sounds like AB 318 was mentioned right before this call. I just want to set expectations. HCD has not taken a position on this bill, and I'm happy to hear questions, but I can't comment on any pending legislation. Let's see. So the program is funded through a $10 per permitted space in the park. Couple things to note: management may pass on a portion or the entire $10 fee amount. We collect it, HCD collects it during the park permit to operate renewal process. It must be if or when that $10 fee is passed on, it must be included as a separate line item in the bill. Park management also must not aggregate it into rent, so it has to be that separate line, and they have to describe what the purpose of that is and contact information for HCD. The intent of this is so homeowners know what they're paying for, how to reach the department, and just the general awareness of the program. There's the complaint intake and referral process that's outlined in statute. I'm going to go over that very clearly. That is in law, and it does provide some timelines that do create some limitations in the program. And I want to be very clear what those limitations are from HCD's perspective, really so that everyone is aware of how best to enforce the MRL or take action on any MRL violations. So, one of my slides went away. It's okay. HCD has 8 nonprofit legal service providers that are contracted throughout the state, and they cover 10 regions, which covers the state completely. And we are required to select a sample of all complaints to satisfy the geographic representation of the state for evaluation. The LSPs were contracted by HCD because of their experience in handling complaints and disputes, matters arising from provisions of MRL, or other matters related to landlord-tenant law. The LSPs have sole authority to determine which complaints will be addressed once we refer them out. Once that complaint is referred to the LSP, it's a relationship between the homeowner and that LSP. HCD does like to know about the outcome, so we can report on the efficacy of the program, but it is it's that relationship is really critical, and that it remain confidential, like any other attorney-client relationship between the LSP and the homeowner. It's also up to the LSP to determine the best course of action. This can be advice and counsel to the homeowner, a settlement or agreement with that park owner. And in some instances, the LSP may find that the allegation has no viable cause of action. So I did want to point that out. One of the things we hear is that the LSPs sometimes find that they have to do expectation setting with the clients, because when they go over what actions they can take, it's really up to them to decide what actions they take further. Mobile Home Residency Law Protection Program, HCD cannot arbitrate, mediate, or offer any legal advice. And this is really critical. Our program is operated by 5 individuals, 1 program manager, several analysts, and 1 technician that intakes the complaints. Our team are not attorneys. We cannot provide legal counsel or advice or mediate between homeowners or park owners. That's really the role of that LSP. We do the best to review our complaint, review the complaints and allegations, and determine if they meet the program criteria. If they are the most severe, deleterious, and economically impactful, and refer those homeowners over to the legal service providers. So I wanted to go over in detail how to submit a complaint. We do have a complaint form online that I'm going to use as a guiding principle in this talk, but there are several different ways you can submit a complaint. First, I want to talk about some key complaint requirements. The law requires that the complainant must be a homeowner. It's defined in civil code as a person who has tenancy in a mobile home park under a rental agreement. So the person has to own the home. They cannot rent the home from the park itself or somebody else. They also must have tenancy in the park at the time that the complaint is filed. This is very critical, and I really wanted to spend time focusing on this. If someone is about to be evicted but files the MRLPP complaint before they are evicted, we can have it continue to move through the process. But if it goes through that eviction process and they no longer have tenancy in the park, the MRLPP program or MRLP program is not able to assist in those instances. So it's very critical that people file while they have tenancy. That is how the law is designed and written. And again, as I mentioned, it's only one avenue for MRL violations to be addressed, but that's a critical distinction. The person must be a homeowner and they must have tenancy in the park. The other key limitation is that violations must have occurred no more than 18 months prior to the receipt of the complaint. So we do review when that complaint or when that violation occurred. It's really critical, again, that complaints are made timely to HCD and they can't be past 18 months. A couple other things I wanted to note: there are no income limits for the program. I've heard through the grapevine that has been a cause of confusion. There's no income limits. It's funded through that $10 lot fee paid for by every resident. So there's no requirement for anyone to be low income or whatnot. And it's very clear that LSPs may not charge clients to provide legal representation. So if either of those 2 things occur, we would really like to know about it at HCD to either clear up any confusion or take further action. So as I mentioned, there are plenty of different ways to submit a complaint. On this screen is a very tiny complaint form. I just wanted to show what it looks like. You can submit a complaint online. You can print the form from the mail. You can call us and we can mail you a printed form, or you can submit the complaint by phone. The complaint, the phone number listed is our Mobile Home Assistance Center. They will guide you through the process. If the complaint comes in on the wrong form, we will work directly with that homeowner to get the key information that is needed. We have complaints forms in both English and Spanish. We do ask the individual's preferred language that they want to communicate in, and we can provide services in any language through our translation service that we contract through with HCD. So what is required? The required information is outlined in Title 25, California Code of Regulations, and the form is designed to collect that information. So if you have the form and you fill it out, you are meeting all the requirements. One thing I really wanted to touch on is the homeowner information that is required. Unlike the Mobile Home Assistance Center, MRLPP does not accept anonymous complaints. And the reason for that is because we do, the law requires that homeowners and park owners or representative go through a good faith negotiation period. We also have to refer that client out to an LSP. And to do that, we need, contact information. Unlike health and safety complaints, MRL is really contractual relationship-based complaints. Health and safety complaints can be observed by, the public or inspectors, and we can go out and inspect that. So we can process Mobile Home Assistance Center complaints anonymously, but the nature of MRLPP complaints does not allow for anonymity. So we require the name, address, telephone number, and if you have an email address, we will take that too. We will communicate in your preferred manner. So if you, prefer to communicate via email, we can do that, or we can keep it through U.S. Postal Service. We ask for proof of home ownership. Again, that's a requirement of the law, and that can be done through providing a copy of your current registration card, the decal number, which we'll then look up in our HCD records, or a formal or informal bill of sale, or that the home was a gift. So I wanted to kind of touch on that for a moment. There are registration and titling requirements for homes, but that is not a requirement of the law. So that formal or informal bill of sale can document if you are a homeowner. We require the park name and information where that alleged violation occurred. And we really like to know of any individuals or park representatives or owners who the complaint has been discussed with prior to filling out that application. Complaint information. So what type of information do we need in order to process and review a complaint? As much as you can, please describe the issue, the concern, or alleged violation, and include all relevant facts. When the violation occurred, the name of any individuals or company that you believe have caused the issue or concern, and any relevant documentation. So lease agreements, park rules, communications, or photographs are really helpful. HCD has to review all of this. There is a document gathering period. Everything that we can get up front is makes it easy to identify which MRL sections may be in violation. It helps us speed along the documentation process, and also to assess the severity of the concern. Again, the law requires that HCD assess how severe, deleterious, economically and materially impactful. The idea of that was the program is self-funded. It's paid for with that $10 per lot fee. It's a pilot program. We did not know how many complaints would be brought in. So at this point, we do have the program is undersubscribed compared to what we initially expected. So we can process a lot more complaints at this time. But should the program see a increase in the number of complaints, we do need to triage and put the most severe forward. So it's really critical that you outline as much detail as possible so that we can make those assessments. You do not need to provide any legal references or citations. You don't need to identify which MRL sections you feel have been violated. We can do that on your behalf. So these are optional things that you can provide. If you have a power of an attorney or a designee, we are happy to work with those individuals. A power of attorney would be somebody who has been legally, that has the legal authority to act on someone's behalf, either through a court order or a legally executed documentation. A designee is somebody just informal that you would prefer to represent you through the process for any reason. Again, we ask that homeowners let us know their preferred language. As I mentioned, we have the forms available in English and Spanish. We can provide translation services in any language upon request. We do have a contracted translator that we work with regularly, so we can do that either over the phone or get documents translated as needed. So I wanted to go over the complaint timeframe. Again, many of these timeframes are set in statute, or regulation. The complaint is submitted to the department online, phone or email. We have 15 days to review that complaint, confirm receipt, and provide a response back to that homeowner about any potential MRL provisions that we see in those alleged complaints. If we don't see any alleged MRL violations, at that time, we will do our best to refer to a more appropriate agency. That could be the Department of Fair Employment and Housing. It could be, your local police or fire, any type of other agency, Department of Aging, wherever we see something more appropriate. At that point, we review the complaint, ensure that somebody is a homeowner, making sure we have all that information that's required for completeness, the contact information, the proof of home ownership, the park information, and we send that letter confirming receipt. And then there's a document request period. So we can combine these two periods of time. We can request documents from the park management themselves. If we do request documents from the park management, they have to supply those documents within 15 days. If they do not, we can take action to cite the park management or their operators for lack of compliance. But it does add a 15-day time period for them to allow them to respond. After that, there is a good faith effort. The law requires that homeowners and park owners act in good faith to resolve the matter between themselves, and they have 25 days to do so. After that time period, if the 25 days has elapsed and neither party has agreed that the issue has been resolved between them, we can then refer that complaint. But we do have to build in that 25 days prior to referral. And I really wanted to talk again about how that time frame works. Especially in the case of evictions. Evictions can move very quickly. It's critical we get those complaints for any type of eviction matter in as early as possible, because that 25 days is very limiting. We cannot refer the complaint to the LSP prior to that. And so sometimes we see these complaints come in and the court order or whatnot happens within that 25 days. It very much limits what action HCD and the LSP can do, even though from our perspective, it would be a serious, deleterious, economically impactful complaint, because it means that someone's going to lose the tenancy in their park and then quite possibly their home. So when you're thinking about making a complaint, please, please, please do it earlier rather than later. It makes the process go much smoother. Let's see. Okay. I'm moving through this much quicker than I thought. So I'm excited that I can go over the status, and I'm sure we'll have plenty of time for discussion if that's okay. So we recently published our report to the legislature. It covers all information from the conception of the program, where we started taking complaints in 2020, I believe, and it goes through July 1, 2020, and it goes through September 29th, 2022, which is kind of an odd date. We tried to wait as long as possible to gather data and still meet our review process. And I wanted to talk a little bit about allegations versus complaints. So we intake a complaint and we read it. In a complaint, there might be several allegations. Somebody may be complaining about lack of proper notice for rent increase, but they also may be complaining about, or complaint, I don't like the word complaining. There might be allegations related to park rules. So there might be one complaint, but multiple allegations. The way that the law required the report is that we outline the number of allegations. So I'll try to stay within, comparing apples to apples. So we took in 3,500 allegations. At that time in September 29th, we'd processed almost 3,000 of them. We had referred 409 of them to other enforcement agencies, and 579 had gone on to the LSPs. So what I see as the most common allegations, and we do outline the number of allegations for each area of the MRL in the report, but these are kind of top 6 in writing and required contents. So that would be the section of MRL that outlines, your park, what's required in that tenant agreement, and you are required to get that in writing, and it has some requirements about what must be included. And you can see that we had just over 350 allegations of that. Amendments to rules and regulations and inadequate notice was also up there with about 230. There are only 7 authorized reasons for termination of tenancy in a park. We got about 280 different allegations of park owners going outside those 7 authorized reasons for termination of tenancy. Inadequate notice of rental increase. Rental increases do require 90 days in most cases, I believe. And so we received just under 150 allegations of inadequate notice. Notices related to utility service billing and the rate schedule was also very similar. And then trees and driveways issues were also about 150. This is a visual representation of where allegations were received by county. You can see LA is very dense. It had 640 different allegations that were referred out, that were intake to HCD. LA has a high concentration of parks just in general, so that's not surprising. But you can see also in this Southern California, Inland and Empire region, there's also a number of complaints that we brought in. So what were the outcomes? This is very tiny, and I don't expect you to be able to read it on the screen this small, but I did want to provide it because a lot of the complaints that get closed, I think we can take some action on. So again, 50 of the complaints were closed because they were submitted anonymously, and we couldn't find the park or couldn't find that homeowner's contact information in order to gather information and describe that they had to go through that good faith negotiation period and refer them onto the LSP. Oftentimes we see that the complainant requests the complaint to be closed. I don't know necessarily all the reasoning for this, but it may be because they are not able to be anonymous. They have to go through that good faith negotiation period for whatever reason. Maybe perhaps it is, the effort. I don't know, but we do see a lot of complainants being request that the complaint be closed themselves. Duplicate complaints, you only need to submit one complaint. If it's multiple people with the same complaint, we can aggregate those. We will not close duplicate complaints. We will just combine those together. So that is an option. If there are multiple homeowners in the same park having similar issues, it can go forward as a group. Either no response or unable to reach that complainant during that time. Again, it's an interactive process. It does require some contact with HCD and with the park owner. So you can see that if we're unable to reach the complainant, we have to close the complaint eventually. They can always be reopened. We can reopen the complaints if someone reaches out to HCD and requests that, so that it's not permanent, but without further action, there's no steps for us to take. Non-jurisdictional, again, we will refer those complaints out to the appropriate jurisdiction and then close that complaint. One of the great things about the good faith negotiation period is that it does provide an avenue for the complaints to be addressed during that time. That's the intent of that period before it gets to legal resources. Ideally, the park owner would make any modifications or corrections at that time, and we can close the complaint. And you can see that 25 complaints with 66 allegations were closed during that good faith negotiation period. Let's see. Same for resolved during that document request. We do see some complaints where perhaps they weren't provided the park rules, and that's one of the complaints. At that point, if we request the document and the park owner provides it, we can complain it because we can close that complaint because there's really no other action to take. Complaint was not the most severe, deleterious, and economically impactful. I don't have all the details on these, but we are required to review them. These could be things, again, like I mentioned, not providing park rules. If those can be handled without going to an LSP, we can close those out. Let's see. Just like HCD requires contact with the complainant, the LSPs have seen similar instances where they don't get a response from the complainant or the complainant requests for it to be closed. At that point, it's far fewer than what we're seeing during the intake process with HCD, but it does happen. We've also seen where at that point, once it's referred out, the complainant itself or complainant themselves would not either sign the retainer or retained their own attorney, and the LSP services were no longer needed. Let's see. As I mentioned, the LSPs have sole authority to provide the best course of action for how they deal with these complaints. You can see 27 complaints with 95 allegations. The LSP provided advice and counsel to the homeowner. The case was resolved in 14 complaints with 38 allegations, either through a settlement, the unlawful detainer was dismissed, or an agreement was reached between the park and the homeowner. That's really, this is the number we really are looking for as, those targeted outcomes. So finally, the resources we have available. We have a flyer in English and Spanish on HCD's website. We're happy to provide information on how to get that. I think if I sent out a slide deck, I'm hoping that it will link to that flyer directly. The Senate Select Committee on Manufactured Housing produces a mobile home residency law handbook that they keep updated. That is on their website, but we also link to it on HCD's site. It has an FAQ document, as well as the MRL itself. We have that complaint form in English and Spanish, and we also have 2 information bulletins on the program and describing the process. So I'm going to send out this slide deck. It has our phone number. It has this email address. We would love to hear from homeowners if they're having issues and want to file a complaint, and we have our website there. So that's the end of my presentation, and I'm really excited to have some time for robust discussion.
So thank you very much, Carrie. Appreciate everything you said. We do have time now to answer questions of a general nature. We can't address any specific complaint because we just don't have all the materials available in front of us. What I would invite all the attendees to do is, if you would like to submit a question, type it into chat, and plan B. So type it into chat, and either I or GSMOL's regional manager for zone A1, Martha O'Connell, will read it. Again, the questions need to be of a general nature, not any specific thing. So in the next few minutes, if you type it into chat, and Deneen Weiler, I think hopefully you can type it into chat. Deneen, let me allow you to unmute, and if hopefully you're asking a general question. Okay.
Yep. And notice.
Okay, Deneen, what's your question?
Oh, hi. Can you hear me?
Yes, ma'am.
Oh, okay. Does the park have to give us a 24-hour notice to come onto the property for anything?
I think that's a general legal question, which is not having to do specifically with the Mobile Home Residency Law program. GSMOL will be sponsoring a talk in April, which is with Bruce Stanton, which is Ask the Attorney Anything.
Oh, okay.
You can also find that information yourself in the that Senate Select Committee's handbook on the Mobile Home Residency Law Act. It describes specifically, there's a section on there on when the park can come in. And if you send a message to me at socialmedia@gsmol.org, socialmedia@gsmol.org, I can send you that Senate Select Committee handbook.
Oh, super. Thank you so much.
So I guess I'm changing the format of the meeting. If anyone has a general question, raise your hand.
Spent more time not answering.
And then,
Henry, Martha's hand, oh, there's hands going up.
okay, and also I messed up. I muted our guest star.
Not a problem. I can unmute when anyone has a question.
Okay, so
Yep.
Next up, Nancy Ross. You may unmute. Okay.
4 years in and I still search for unmute. What the heck is wrong with me? So I just have a question, and this may be, I don't think it's of a legal question, but it may be. Can you define if an occupant or a companion is a guest or a resident, as the laws are different on how they're treated?
I cannot. That is very much in the MRL. I am prevented by law to provide kind of interpretation and of that law. But again, everything that Henry provided with access to that MRL handbook, I think should be in there.
Thank you.
Okay. And there's a general question. Carrie, do you know, can you describe the general reasons why a complaint dismissal, why complaints are dismissed?
Yeah, so a complaint would be dismissed, again, if we don't have contact information for that individual. We have to have contact information for somebody to help them through that process of good faith negotiation and working directly with the LSP. A complaint would be closed if we're not receiving any information back for them. So if we are, and this is on the homeowner side, if we are requiring additional documents, or if they filled out the complaint form without signing it, we need that. And if we reach out several times and don't hear back, it's going to be closed at that time.
Thank you. Gail?
Henry, this is
Yes,
Linda.
ma'am.
Martha has been up for a long time. I don't know if she has questions from people or not, or she's muted.
Okay. Martha, unmute. Ask your question.
Yeah, I have two quick general questions. Carrie, a few months ago, I was the designee on an MRLPP thing, and that was all the person had to do. During your presentation, you mentioned power of attorney. Is the form still the same, that we do not need to get a power of attorney? She can just say that you're nodding yes.
Correct. Yeah,
Okay.
correct. So the form, and let me see if I have it up on my screen. I can show you the complaint form. Give me 1 second. It does indicate a checkbox. Let me just share my screen again. So you can see, and this is all optional. Now you can see, it's all optional if, oops, where did it go? Zoom. Apologies. I've lost everybody. Let me try that one more time. Okay, so you can appoint a designee. This is just if it's somebody you want to represent you during the process. If you have an authorized designee, this is somebody who has a court order that's been legally executed. Either they have a power of attorney or court order. Couple other things on this complaint form. This is really critical. It does need to be signed. You're certifying under California laws that the information is true and correct to the best of your knowledge. That's another thing we see often, is that it's not signed, and then we can't reach out. And then the person, if you don't sign it, we can't continue processing that complaint.
Okay, my second general question is, and I've heard this from several people, not just from the person who put it in the chat. For the purposes of filing a complaint, what do you specifically require to prove home ownership? Thank you.
Mm-hmm. Let me try this again. So these are some of the things that you can do to prove home ownership. You can provide that decal number and we will look it up. Okay, sorry about that. You can provide this decal number and we will look it up. You can attach any type of documentation you have, like certificate of title, any rental agreement you have with your name, or other type of proof of home ownership, such as a bill of sale or something documenting that it was a gift. Or any type of proof of acquisition from a deceased prior owner. So those are some of the ways we can do that. We will really work with you to see what we can use to provide proof of home ownership. These are examples in the law, but I believe that the law does allow us, it states that they are examples and we can take other things as well. Did that answer your question, Martha?
Yes, it did. Thank you.
Mm-hmm.
Okay. So, Mei-Ling, you may unmute.
Hi. Okay. I have a question. I have many new residents. They complain to me about they never receive their park rules copy, or or any lease agreements
Mhm.
copy and application forms copy and all the copies. And is that right? Because when I move in, we receive all the copies of everything, like park rules and, and other things. And then is that correct? The part they requested, but the park did not give it to them.
Yeah. So that is a great example of something that should be put in through the MRLPP. If it's more than one person, we can aggregate those complaints. When I did go over kind of our most common complaints, that's what I see. A lot of people who are alleging that they had not received their park rules or their lease agreement. So please, have people put in their intake form and we can have them go through that process.
Okay, because I'm helping them, and they told me that if we don't, they got some, like 7 days notice to correct some of their yard and so on and so forth. And they say, we don't have any park rules. How do we know what is the rules I should, comply? So that's why, I told them, I say, I will check with them. And so we can actually file complaints, right?
You can put the complaints in. If you have more than one person, we can aggregate those together. And it can go through that MRL process.
Great.
That is
Thank
something
you.
common one of our more common allegations that we see.
Okay, thank you.
Before I ask the next person, there are many questions in the chat that are coming of a specific legal nature. Is this a feature of law? Can we do this under law? And unfortunately, that's beyond the scope of this talk. Those are questions which are best directed to an attorney. And next month, GSMOL will be having an Ask the Attorney session with the corporate counsel, Bruce Stanton, and he can answer those questions. Let me go on to Skip. Martha, you have first dibs, otherwise on to Skip.
No, I'm reviewing them. And yes, folks, if you have a specific legal question, this is not the seminar to do it. Thank you, Henry.
Okay, Skip, you're unmute, please.
I'm sorry, I showed as unmuted, so I don't know what's going on.
No, Skip, unmute.
Oh, sorry.
Sorry, yeah, it's all right. Going once.
Here.
All right.
Hello.
Hi.
I'm Skip's wife, Kay. So by my calculations, and I may have made some math errors here, but about only 14 cases have been resolved to the complainant's satisfaction, and that out of 3,600 original applications. It looks like it's very difficult to get help from MRLPP. But I was wondering if that's maybe because so few people know about it, and will there be an extension of the sunset date so that there's a chance for people to actually use this assistance? That's it.
Yeah,
That's my question.
yeah, I can address some of those aspects. So let me start with the 14. So again, there's many different ways to resolve a complaint. If the complaint is that someone doesn't have their park rules, or we're not given a copy of the MRL, or perhaps don't have their lease agreement, those issues can be resolved either through the good faith negotiation period, or that document request period. Advice and counsel from the LSP is also another way to resolve those complaints. The LSP can work directly with the homeowner. So there are only 14 cases as of when we pulled that data, which was September of last year, that had reached some type of other, agreement. So either a settlement or a unlawful detainer was dismissed. I think to your second point about the undersubscription, I agree with you. I'm very thankful to do this today because I think the more people that know about the program, the better. HCD is working to execute a outreach contract that will provide statewide public awareness and outreach on the program, working in individual communities multilingual collateral will be developed. So yes, I think as much as we can do to get that outreach and public awareness, the better. And then your third point about the sunset bill, again, I think GSMOL has sponsored legislation. I can't speak to what will happen. Again, that's with the legislature at this time. As HCD is a department within the administration, our job is to execute legislative requirements. So if the legislature passes that and it's signed by the governor's office, we will of course continue the program, but we can only work within the confines of statute. Did I get all your points?
It's Henry, where did he go? Henry's on mute. I see Dave T. His hand is up. Dave? Dave?
Am I here?
Yes, you're here.
Okay.
Go ahead.
I was wondering if the chart that was provided were the most egregious allegations, I guess is the word. Because I've made a few complaints and basically gotten the answer that it's no big deal, forget about it.
Okay. So Dave, I don't have the information about your specific complaints, but I'd be happy to talk with you or have our program manager talk with you further about any of the specifics of your complaints, at a later date.
Okay, well, what about my question and the chart that you provided? Were those
Could you clarify? Could you clarify your question for me?
I didn't take a picture of the chart, but you had like several hundred of these types of complaints listed. The name of the complaint and how many of them were there. I believe it was blue lines going across.
Yeah, let me pull it back up. Hold on. Could you clarify what you're asking about it?
Was that what is considered most egregious, the ones that the MRLPP will address?
Oh, let's see, hold on. Are you asking if these are considered the most egregious?
Yes,
Yeah,
exactly.
no, we're not. I just went through the report to the legislature, which I can email out to Henry and he can provide that. These were the most common allegations that we've seen.
And in the big lettering, you think I might have been able to see that, but no, I didn't.
It is still very early. There is the report itself. Let me see if I have it up. Hold on. It's going to be really difficult to see on this screen. It goes through each of the sections, the articles of the MRL. So you can see the MRL has, 7 different articles, and we intake complaints and we try to assess where they most fit in. So for Article 3, there were 136 allegations on violations of application to park owners and employees. In Article 4, which deals with utilities, there are 145 allegations relating to utility service and billing. I went through this report this morning and just tried to pick out what we see as most common. Obviously, most
Gotcha.
common is very much related to violations of the rental agreement in writing and required contents. And I think that was one of the questions that was brought up earlier about if that's something that MRLPP would address. It is a violation of, or it is a common complaint we see. So it's just most common.
Okey doke. Thank you much.
Yeah.
Angela, I think you'll have the last question. Go ahead.
Hi. So I'm just curious about why there's a problem with the signature on the complaint. Is there a wet signature required? Do people have to sign it with a pen and scan it and then send it to you? Or is there an electronic?
No, it can be there. I don't believe that the law requires a wet signature. It's just people, for whatever reason, not signing it. But the law does require that it is signed.
And so if you're doing it online, can you just type your name in online, and does that constitute a signature? Or?
Great question, Angela. I don't know offhand, but we do accept, let me think through this a little bit. We do accept complaints online, and those are obviously typed. I'd have to go through that complaint process. I think it's just, verifying that you are acknowledging that you're providing information that's true and correct.
Okay. Because that seems just like an obstacle to, there shouldn't be an obstacle.
Yeah, we do provide complaints online. You can submit it through a complaint portal where you would, type it. So I don't want to say I definitively know how that program is operating if it's a typed signature, but with it being online, that is typed itself. I think it's the acknowledgement that we need.
Okay. Thank you.
Yeah.
And before I ask Linda and I to give us some closing comments, we've discussed several documents that are here. I posted the MRLPP, Mobile Home Residency Law Protection Program flyers in English and Spanish. I've posted the complaint forms. If there's any documents that we've talked about today that you would like, email me at socialmedia@gsmol.org and I can send them to you. Those documents might include those complaint forms that I talked about, the slides that Carrie used, the Mobile Home Residency Law Protection Act, or Mobile Home Residency Law that the Senate Select Committee has produced, the reports that HCD has given about the MRLPP, both what are called the task force reports. Every 6 months, they give a summary to it, and the summary that HCD gave to the state legislature about the MRLPP. And also, at the end of this session, you'll get a invitation to fill out a survey about your information about the MRLPP. It will help us understand how to do this. And so, Linda, I'd like to turn the meeting back to you for closing comments.
Okay, thank you. I've got to get my notes out. I just want to reiterate what Henry just said. There will be a short survey about the experiences with the MRLPP. This will help us improve the program. I am assuming it's going to be in the chat. Is that true, Henry? I hope.
What will happen is when you close your Zoom session, your browser will pop up with the link to the survey.
Okay, thank you. MRLPP will end this year as of December 31st, unless the legislation to continue it is enacted. Legislation is AB 318 and is sponsored by GSMOL. Please visit gsmol.org on the homepage for more information on that. It's really important because we'll have nothing if this sunsets. Okay. Like I said, this is our primary bill for the year with the legislative action team. Okay, I'm going to learn how to talk someday too. Information to file complaints, get help from GSMOL, and how to get the presentation slides and survey will be displayed in the closing screen. Okay, so if you have any, most of your questions, well, you can get something displayed in the closing screen, which will explain to you how to do it, how to do the complaints, how to get help from GSMOL, and how to get the presentation slides. And that's basically it. Thank all of you. I want to thank all of you for attending. This really helps us, and it helps us help you. Okay, so thank you very much.